this conference, which I think has been phenomenally successful. And also I see some new faces that have wandered in, and also welcome anyone who has just arrived for the conference. So this particular session is going to deal with resources on reservations. And I'm going to moderate the panel. My name is Buzz Thompson. I'm a professor here at Stanford Law School, also one of the two directors of the Stanford Woods Institute for the Environment here on campus. Had the privilege of helping serve the faculty sponsor of NALSA for a number of years now. And I happen to be joined by two extraordinary co-panelists. And why don't I introduce them in the order in which they're going to speak, and then I will just let people go ahead and do their presentations. So to my immediate left, your right of me, is Seth Davis. And Seth is the Clemenco Fellow and Lecturer on Law at Harvard Law School. Seth received his Bachelor of Arts in Anthropology and English from Davidson, and then went on to get a Master's of Science in Anthropology from the London School of Economics and Political Science, and then his JD from Columbia Law School. He clerked for Doug Ginsburg on the DC Circuit, and since I was once a partner of Melvin Myers on the police, you see, he was also for a period of time with Melvin Myers before he went to Harvard Law School. And then at the other end of the table from me is someone who I have long known and whose work I admire, Robert Anderson, who's the director of the Native American Law Center and professor of law at the University of Washington School of Law, and to show that Harvard is doing a lot in the Native American area. He also is affiliated with Harvard, where he's had a long time appointment as the Oneida Indian Nation visiting professor of law. One of the things I have to say, though, is I think both Harvard and Stanford should do something about getting a permanent Native American faculty member who teaches law at both of the two institutions. Robert also is one of the co-authors of Cohen's Handbook of Federal Indian Law and the leading American Indian Law casebook. He at one point worked for NARB and also advised Bruce Babbitt when he was Secretary of the Interior. So, as I said, two fabulous co-panelists, and we're going to let Seth go first because he's going to be the person who doesn't talk about water.
That's right.
And Robert will give a broad view of some water issues, and I'm going to narrow down just a couple of subtopics. So, Seth.
Thank you. So my talk today is on energy governance in Indian country. And I want to begin with a story about coal. Coal in Indian nations have a long history. The Hopi used it to heat pottery hundreds of years ago. Many Indians have worked as coal miners since America began consuming coal. And today, some Indian nations are discovering that the path to self-determination may be lined with coal. To the Crow Nation, as Senator C.J. Stewart put it, coal is the way we've been taking care of our people. Crow has contracted with an energy company to lease its 1.4 billion tons of coal, much of it destined for markets in Asia. The nation stands to gain millions in revenue, job preferences for tribal citizens, and scholarships for Native kids. It all depends, however, on whether the coal can be transported and exported through the Pacific Northwest to Asia. And that's where the story of Indian energy self-determination becomes really complicated really quickly. The affiliated tribes of Northwest Indians oppose the transportation of coal through the Northwest, citing potential impacts to their environments and treaty rights to fish, hunt, and gather food. They've actually passed a resolution encouraging the Crow Nation to explore alternative domestic uses for some of their coal. As the Yakima chairman, Harry Smiskin, put it in a letter to the federal government, there's been a long history of treaty violations from energy development in the region that have permanently and irreparably damaged its people. And yet, Crow Nation Chairman Darren Old Coyote has responded with a strong claim on behalf of his people. Given our vast mineral resources, he explains, the Crow Nation can and should be self-sufficient. And who is anyone to argue with? As Senator Stewart put it, we rely on coal just as the Northwest tribes rely on fish. All tribes share one common enemy, and that enemy is poverty. Today I want to unpack the implications of this story for how we think about energy governance and Indian nation sovereignty. My aim isn't to say whether the Crow are right or the Northwest tribes are right. I think both are. Rather, I hope to convince you that we need a new way of thinking about Indian energy self-determination. Now, traditionally, scholars have thought about energy governance by asking which sovereign should control which dimension of energy development. There's a steady stream of law review articles, for instance, on whether the federal government or the state should control something like, electricity transmission siting, and actually, I'm guilty of publishing one of those articles. For the most part, we've talked about Indian energy self-determination in similar terms, with a particular focus on who gets to control energy extraction and generation on Indian lands. So there's been a steady stream of articles arguing for more Indian control and less federal control over the leasing of Indian nation's natural resources. Today, I want to talk about what gets missed or misunderstood when we focus upon Indian energy self-determination in these terms. In particular, I want to convince you that relational sovereignty is a better way to think about Indian energy governance. And I mean three things with this claim. First, energy self-determination in Indian country explicitly involves not just a tribal government's control over its property, but also duties that it owes its citizens and its environment. As, again, Crow Senator C.J. Stewart put it, energy development is the way the Crow Nation is satisfying its duties to its people. The second point I want to make is that Indian energy self-determination depends upon Indian nations' relationships with other governments, regional institutions, and private and public markets. The Crow Nation's coal initiative, for example, involves not only the Crow Nation and its private partners, but also other Indian nations, state and local governments, environmental nonprofits, and in fact, even implicates the Chinese government's energy policies. And whether the Crow Nation succeeds in its drive to self-determination through coal development depends, therefore, upon much more than its mineral property rights and its territorial sovereignty, the usual points of focus when we theorize about Indian energy self-determination. And the third point I want to make is related. Indian energy self-determination encompasses exercising sovereignty outside the reservation, including participating in federal administrative regulation of energy development. Think about the Northwest tribes' attempts to assert their treaty rights regarding coal transportation through federal administrative processes. So my remarks today are part of a larger project, and they're really a first step in a larger project I'm working on with a colleague, Sharon Jacobs, on rethinking about how we govern energy development. And as a first step, it's necessarily impressionistic. My hope at the least is to identify some practically important problems that we may be missing or misunderstanding under our current ways of thinking about Indian nations and energy governance. The irony is that just as Indian nations are making important strides towards energy self-determination, we're becoming aware that the problems of energy governance can't be solved simply by the recognition of strong property rights and the assignment of authority to the right sovereign. That's not to deny that federal law has created significant and unjustifiable barriers to energy development in Indian country. And let me give some background on that. Let's consider first the development of traditional energy resources like oil and gas. The problem here begins with the trust relationship between the federal government and Indian nations, with federal law limiting tribes' property rights and federal agencies acting as quote-unquote guardians over tribal resources. Under the Indian Mineral Development Act, for instance, an Indian nation can't enter into an agreement to develop traditional resources like oil and gas without federal approval. The federal administrative process is, in some ways, broken. It's fragmented among multiple agencies and it's full of bottlenecks. The process has as many as 50 steps. And moreover, the Supreme Court held in Cotton Petroleum Corporation v. New Mexico that states may tax non-Indian lessees, notwithstanding an earlier federal statute, the Indian Mineral Leasing Act, which creates a double taxation problem that increases the cost of energy development in Indian country. As a result, energy development in Indian country has been slower, and it costs more than similar development under state law, which encourages energy developers to look outside Indian country. And because few Indian nations have the capacity to develop their oil and gas resources on their own, discouraging non-Indian developers from partnering with tribes can be tantamount to discouraging traditional energy development in Indian country. Now, it's pretty easy to tell a similar story about renewable energy in Indian country, but there's been some recent developments that are somewhat more encouraging, if still problematic. So just last year, the BIA had new regulations that went into effect that try to revamp federal review of non-agricultural leases of tribal lands. The new regulations, among other things, aim to speed up review of wind and solar projects. And they also require the BIA to defer more to Indian nations' decisions. For example, under the new regulations, the BIA has a short deadline, 60 days, to review a lease to generate wind and solar power. And importantly, the regulations address the double taxation problem too, by preempting state taxation of permanent improvements on leased land. And as I got this from Turtle Talk, which Matthew runs, just a week or so ago, a federal district court dismissed a challenge to this preemption provision of the regulation. Now, these regulations are potentially encouraging for renewable development in Indian country, but there's a few obvious potential problems. For example, will the BIA meet the short deadlines? And if not, are tribes going to be able to compel agency action quickly through courts? As an administrative law scholar, I have my doubts about this. Now, Indian nations have experimented with contractual solutions to all these bottlenecks created by federal regulation. The tax implications of these agreements can be complex, but there's some encouraging developments here in the administrative arena as well. The Internal Revenue Service just recently issued a private letter ruling allowing a specific Indian tribe to pass through the federal renewable energy investment tax credit to a private development partner. This tax credit can be worth up to 30% of a project's market value, and so it's a strong incentive to engage in renewable energy development. But my sister, who's a tax scholar, tells me that these private letter rulings, of course, are not precedent within the IRS, and so an important thing for tribes trying to think about utilizing this seeming new policy is perhaps getting their own private letter rulings. In any event, perhaps the most important recent developments have actually been statutory. In 2012, Congress enacted the Hearth Act, which creates an opportunity for Indian nations to decide how to lease tribal lands without the BIA second-guessing every lease. In particular, the Hearth Act allows Indian nations to opt into processing leases of surface rights on tribal lands. So it's relevant, obviously, for renewable energy development. Now, to opt in, a tribe has to get the BIA to approve its leasing regulations. Once the regulations are approved on the wholesale level, an Indian tribe can decide on the retail level whether to lease a particular parcel of tribal land. Now, to get BIA approval, and this harkens back to something that we've heard about already, including from Angela Riley, a tribe's regulations must, among other things, require review of the environmental impacts of a proposed lease, including public notice and comment, the same kind of review we see under the federal NEPA. Now, I'm encouraged actually by the BIA's interim guidance on how the Hearth Act is going to be implemented, because this guidance states that the BIA has an obligation to maximize the deference it gives to a tribe. Now, the interim guidance just expired about 15 days ago. But I'm hopeful, and I think we can expect that the current BIA at least will stick to this deferential approach. So anyway, the Hearth Act, I think, is promising, but it's far from a guarantee of Indian energy self-determination. And many Indian nations may not opt into the Hearth Act scheme. In this regard, the track record under earlier similar legislation really isn't promising, unfortunately. In 2005, Congress enacted the Indian Tribal Energy Development and Self-Determination Act, which I'll refer to the TIRA Act because I can never pronounce the actual acronym. The TIRA Act creates a regime a lot like the Hearth Act, but for traditional as well as renewable energy resources. And so far, no Indian nation has actually tried to get TIRA approval. And actually, so far, only 3 have gotten Hearth Act approval. Now, much of the debate about TIRAs and the Hearth Act is played out in familiar terms. For instance, the Hearth Act's been criticized as inconsistent with tribal sovereignty because it encourages Indian nations to enact environmental review processes into tribal law. The thrust of this way of thinking really gives us a pretty stark choice. Either we're going to have tribal sovereignty or federal supervision and liability. Or as energy scholars might put it, all we have to do is match the right sovereign with the right dimension of an energy problem. I think we need to think differently and more comprehensively about Indian energy self-determination. I even think administrative review of environmental impacts can be a good idea. And Indian nations looking to create these processes can look to other tribes' laws, not just the federal or state governments, for models. And I don't think there's anything necessarily problematic about Indian nations cooperating with other sovereigns in the development of energy resources. Indeed, what I'd like to convince you of now is that such integrated decision-making is actually an inevitable feature of energy governance and necessary to the success of Indian energy self-determination. Why might that be so? Let's step back from the federal Indian law context for a moment and just think about energy development. It's an unusually complex problem. First, you have to harness natural resources. Then you have to generate energy. Next, you have to transmit the energy, transport it to where it's needed. And finally, you have to distribute the energy to the people who are actually going to use it. As a result, the benefits and costs of energy development cut across global, national, regional, and local boundaries and end up being unevenly distributed. The problems end up being physical, scientific, technological, political, and economic, not to mention regulatory. A host of public and private stakeholders end up getting involved in most development decisions. Indian nation sovereignty with respect to energy extraction and generation, the leasing, say, of surface and mineral rights, is but one aspect of this global system. And the Crow Nation's coal development story is just one example of these complexities. Indeed, Indian nations themselves have recognized the relational nature of energy governance. Consider, for example, the Swinomish tribe's 2007 proclamation on climate change, which discusses the problems of energy development and its impacts. And I'm going to quote it. The effects of climate change, while evident globally and regionally, have significant impacts on the local community due to rising temperatures, rising sea level, and other associated effects on the local environment. To address these impacts, the tribe's proclamation goes on, it is necessary to communicate and coordinate with local, state, regional, and national entities and jurisdictions, including government-to-government cooperation. Now, energy-producing tribes are also taking stock of the relational nature of energy governance. Last year, the Navajo Nation rescinded its 1980 energy policy in favor of a new one, designed to build the nation's capacity across the multiple dimensions of energy generation, transmission, and distribution. The policy aims to integrate traditional and renewable resource development, both to, quote, establish energy independence and build the Navajo economy, and to make Navajo energy an important part of the regional and national energy grid. I think these tribes' energy policies point towards a new way of thinking about Indian energy self-determination. I call this new way of thinking relational sovereignty. Scholars of international human rights law have defined relational sovereignty as measuring a nation's sovereignty by its duties to take care of its citizens. That's opposed to thinking of sovereignty in strictly territorial and jurisdictional terms. The kind of thinking that's behind energy law scholarship's traditional focus on scale matching between a particular sovereign and a particular dimension of energy regulation. Now, I mean to use relational sovereignty in this sense, to refer to a sovereign's duty to its citizens. But that's not all I mean by the term. One of the most striking features of Indian energy self-determination, to my mind at least, is the care with which Indian governments frame their sovereignty in relational terms. To return to the Navajo Nation's 2013 energy policy, for example, it states, and I quote, "The nation can make improvements in the area of governance, ownership, management, community involvement, health impacts, conservation and environmental protection of the nation's energy resources." The nation's Natural Resources Protection Act, which bans uranium mining, explains it is the duty and responsibility of the Navajo Nation to protect and preserve the natural world for future generations. Now, you'll search all the thousands of pages of the Federal Energy Policy Act of 2005, in vain for similarly forthright statements of a sovereign's duty of stewardship toward its current and future citizens. Recognizing this quality of Indian energy self-determination has important implications, and let's consider one. Indian nations, to satisfy their duties towards their citizens to create energy independence, may want to set up small-scale projects, like distributed renewable technologies, a few solar collectors, for example. And that a tribe that wants to engage in this kind of development, it doesn't have an incentive to go through the laborious Hearth Act process, but I don't think it should have to wait on the BIA for years either. We should think about redesigning the system to address distributed renewable technology in Indian country as its own category, and to recognize that Indian governments can be renewable energy pioneers as stewards for their citizens and their environments. That may mean federal funding under the trust relationship, but it should mean federal second-guessing of these local tribal decisions. The second sense in which Indian energy self-determination is relational concerns an Indian nation's relationships with other governments, regional institutions, and public and private markets. There's a lot to be said here, and a lot I think that the existing literature has missed, but let me focus on one often overlooked aspect. Increasingly, regional organizations are emerging as important sites for energy governance. And I don't think that should be any surprise. Think again of the Crow Nation's coal development. Let me give you one example from the West. The Western Governors Association has created a collaborative regional process in the design of renewable energy production. The association, in partnership with the Federal Department of Energy and 2 Canadian provinces, has identified a whole map of renewable energy zones throughout the West. And the association's next aim is to address the political and regulatory obstacles to the permitting and construction of cross-jurisdictional transmission lines and renewable energy projects. To my mind, recognizing the growing importance of regional organizations in energy governance leads to think about how Indian nations could have a seat at these regional tables. It may require pushing for more autonomy from the federal government. It may mean making more liberal use of the public comment periods that organizations like the Western Governors Association often use. It could even mean trying to get a seat at the table in regional steering or technical committees, where much of the planning for the creation of regional energy parcels takes place. I'm honestly not sure what the institutional design possibilities are, but I am sure that there's a risk that these regional organizations could try to eclipse Indian nations' interests. And so I think participation in regional energy governance, which you haven't really talked about in thinking about Indian energy self-determination, could be an important part of the overall puzzle. The third and final sense in which Indian energy self-determination is relational concerns sovereignty outside the reservation. Again, there's a lot to be said here, but I'll focus on one administrative law problem because that's the kind of thing that I find interesting. Indian energy self-determination involves not only tribal development of energy generation, but also a tribal say in energy development that impacts the tribe and its citizens. When it comes to energy development, Indian nations often find themselves consulted by federal agencies at the last possible moment, not at the earliest. And I think we need an administrative law fix to this. The Council on Environmental Quality actually has issued policy memos urging federal agencies to involve Indian nations as cooperating agencies, which would get them involved in early stages of NEPA review. Maybe this policy needs to be made binding by regulation or statute. If so, it could recognize a crucially important relational aspect of Indian sovereignty over energy development outside the reservation. So let me conclude where we began. As the ongoing controversy over the Crow Nation coal development suggests, the problems of Indian energy self-determination are not easy, and they're not reducible to tribal control over energy generation on Indian lands. Thinking about Indian sovereignty in relational terms isn't a solution, but perhaps it's a first step towards sovereigns approaching each other with mutual respect as stewards of their natural resources for today's generation and the many still to come. Thank you.
All right, thank you, Seth. And I'm going to launch right in here. I think there's a PowerPoint that's going to go up there with some pictures for you all. But I want to thank Nikki and Cora. Well, where are you? Right there. Corey, for setting up the conference. And it's great to be here. Thanks for staying so late in the afternoon.
encourage the students to keep on with the second and third and the fourth and the fifth. I think back to the Federal Bar Association conferences, which are wildly successful now. They're so large that some of us don't like to go anymore because there's so many people there. But I remember speaking at it in like 1985, and there were 65 people in the room, and it was held in Phoenix, and not much going on, and it was a one-day deal. So I think if you keep it going, you'll have a huge success down here. I'm going to talk about water quantity and quality regulation in Indian country. To do that, I want to first give you a brief overview of some really basic water law principles, and then Buzz is going to, I think, pick up a little bit more with layering on some of the complexity that I'm going to gloss over so that I don't take up 2.5 hours. We've got a basic state water right regime of prior appropriation. Basically, we say first in time is first in right. So it rewards the first person to sort of raid the river or the lake and put the water to a beneficial use, which traditionally would have been mining, irrigated agriculture, domestic uses, and so on. Leaving water in a river for in-stream flows, that wasn't considered a beneficial use. I was digging around in the law library one day, and this is the benefit of going into the stacks. Instead of doing everything online, I was looking for a public land law book, and I happened across a Bureau of Reclamation report from 1952 involving water resources in Alaska. And the Bureau of Reclamation had done a comprehensive study of power sites and potential water use in Alaska, and this is part of the run-up to statehood. Then I opened up the front cover of this sort of tattered book, and there it was emblazoned in italics, 24-point type or something. Wherever water runs into the ocean or salt water, there is waste. And the idea being that if you have one drop of fresh water that's not being put to some sort of consumptive use out of the river, that's a bad thing. This is 1952. And this whole prior appropriation regime encouraged that sort of water use, the diversion from a river in order to acquire a right to use that water under state law, accompanied by the notion that if you stopped using it, you were guilty of abandonment or relinquishment under state law, and you lost that right, and some other person who came along later could acquire that prior right. Now, I haven't mentioned depletion, consumptive use, or return flows, which Buzz has got a special master's report that he wrote in the Montana versus Wyoming Supreme Court case that I reread on the way down here. I hope we'll talk about that a little bit and the complexities involved in these seemingly simple concepts in their application. And it's amazing to me that after all the years of litigation, there are so many aspects of state water law and federal Indian reserve rights and federal reserve rights that have not been fleshed out. And that sort of fits with my general theme that I'm going to talk about today, that I've written about in the past, is that sort of uncertainty as a matter of theory and uncertainty as a matter of application of the law through these fragmented federal and state court decisions that are out there really encourages intergovernmental cooperation. Actually, in the use of water, in the allocation of resources, and in the implementation of federal statutes, tribal law, and state law designed to protect and enhance water quality. And that's sort of the theme of an article that I'm working on to examine some of these prospects for intergovernmental cooperation, because it really is necessary as the world stands now, but even more so as old water right decrees are made obsolete due to climate change, melting glaciers, changing hydrograph, groundwater depletion. Things have to change in terms of how these rights are managed. So, on to 2 seconds of Indian reserved water rights. Their Indian treaties are the supreme law of the land. There are basically 2 types of reserved water rights that I'm going to talk about today. Number 1, due to the predominant policy of establishing Indian reservations for purposes of turning Indians into farmers during the 19th century, the Supreme Court has recognized that tribes have reserved rights to water for irrigation purposes. More about that later. Secondly, many tribes, particularly in the Midwest, the Pacific Northwest, Montana, also were heavily dependent on fishing. And lower courts, Ninth Circuit, state courts have recognized that tribes also have retained reserved water rights for in-stream flows to protect those fisheries. We say typically that treaties are not grants to the Indians, but reservations of rights reserved. And the primary example of that is the Winans case from 1905. That's the Columbia River up there. And that case deals with the usual and the custom station where the tribe reserved the right to fish along the Columbia River. And the Winans Brothers were private landowners somewhere along those uplands there that had received a patent from the United States. One day they noticed the Yakima tribal members crossing their property to get to their fishing site in the springtime when the salmon were returning. And the Winans Brothers looked, I suppose they looked at their patent and didn't see anything in there about an easement to cross their land. And so Charles Wilkinson told me I have to say this every time I tell the story. So the Winans Brothers said, go away. And they went away. They went to the Supreme Court. The Supreme Court in U.S. versus Winans ruled that there was an implied easement across that private land. That the tribes retained the right to fish at that usual and custom station, and they also retained the right to cross private property to get there. And that notion of implied rights was given further meaning in Winters versus United States 3 years later, and where the Supreme Court adopted the rule known as the Winters Doctrine, that when land is set aside by a treaty or agreement with a tribe for Indian purposes with an agricultural bent, in this particular case, that there's sufficient water reserved to allow the tribe to irrigate that land. This was the case even though the non-Indians who were watering their lands from the same river had begun their use first. So the state law of prior appropriation, which would have protected the state law users, on this case out of Montana, was trumped by the fact that the reservation had been created prior to the non-Indian use. So the government was said to have reserved the water in 1888 for subsequent use by the Indians, even though there was intervening non-Indian use that had occurred. So Winters and Winans together create a formidable bulwark for the protection of Indian rights to make use of their reservations, whether for agricultural purposes or later we'll see for protection of in-stream flows. So you might have thought that these early decisions would have protected tribal rights going forward, but instead we see the Bureau of Reclamation hell-bent, pursuant to congressional funding, building reservoirs and irrigation projects throughout the West. I've seen accounts of correspondence from the poor, underfunded BIA from as early as 1910 saying, all the lawyers and all the engineers are in the Bureau of Reclamation. We have no money to protect the Indian rights recognized in the Winters case. So what? On it went. The United States built these projects, encouraged non-Indians to come out and settle in areas that were open for non-Indian settlement through treaties, creating an eventual collision that comes to the forefront in the 1970s when we really get a huge amount of litigation over these Winters rights and state law appropriators who in fact were putting the water to use. And the decrees that were entered in the few cases after the Winters case didn't say how much water the tribes were entitled to on a permanent basis. You had this cloud created throughout the West on non-Indian projects. It didn't really stifle non-Indian development, but it was a legal cloud on that title. Arizona versus California, massive litigation, I think concluded now after about 60 years, over the use of all the waters to the Colorado River, pursuant to the Colorado River Compact. So it's Supreme Court litigation, special master reports, wonderful reading, and the United States intervenes on behalf of Indian tribes along the Colorado River in order to protect their rights. And there you see a map of the river, thanks to our friend David Getch's The U.S. asserts reserved water rights for the Indian reservations and for the non-Indian federal reservations. And the special master writes a report and says, well, we're going to set out a method for determining the final amount, the full quantity of rights that the tribes are entitled to, not just now, but in the future. And he adopts a measure known as the practicably irrigable acreage doctrine, which basically says, if you can show that you could farm that land and break even through some sort of an engineering study, you get enough water to irrigate those lands on the reservation, and awards a significant chunk of water to these Colorado River reservations. That PIA standard becomes the measuring stick for about 55 related pieces of litigation involving Indian tribes throughout the West, even though it's been endorsed only by one Supreme Court case in 1963, reaffirmed in 1980 as to the Colorado River. 1970s, fast forward. The McCarran Amendment, a termination-era statute, granted state courts jurisdiction to adjudicate federal and Indian reserved water rights. It waived the United States sovereign immunity in state courts and told the states that if they chose to adjudicate all waters within a particular river basin, they could drag the United States into state court as well. Two Supreme Court cases later, they say, and it also includes the right to bring Indian reserve rights in because the United States holds legal title to those rights as a matter of federal Indian law. So the states really don't exercise this authority until after the 1973 National Water Commission report essentially castigates the United States for its poor record in protecting Indian rights up to that point. And so this is Richard Nixon's very progressive Indian policy, followed up by President Ford and Jimmy Carter, and the United States commences a large number of adjudications on behalf of tribes in New Mexico, Arizona, Colorado, and Montana. And so states react to this in a way that is perfectly natural. They commence their own adjudications, win the authority in the Supreme Court to adjudicate these cases in state court and under the abstention rules that are announced in Colorado River Conservation District, a case you probably all read in civil procedure and federal courts. So, state courts have jurisdiction over these federal and Indian reserved water rights. The state courts have not litigated many cases to a final decree. One case in which the court did announce a final decree was the Bighorn case. It only took about 15 years, pretty relatively young for a water rights case. And the court, the Wyoming Supreme Court, adopted a pretty generous interpretation of the reserved rights doctrine. But they refused to award water to the tribe in the United States for fisheries. So the cases went up to the Supreme Court, and the Supreme Court granted cert only on the state's petition. And just before the decision was about to come down, Justice O'Connor recused herself, discovered she had a conflict. And so it was a 4-4 affirmance. Several years later, David Getchis again, combing through Justice Marshall's papers at the Supreme Court, discovers this so-called phantom opinion that had been written by Justice O'Connor that would have fairly dramatically altered the reserved rights doctrine in favor of the state position. And so that sent sort of a shockwave through the tribal attorney bar that, gee, this was very close to being a significant defeat to the tribal and federal position in these cases. And so that caused some rethinking about how to litigate these cases, and also about, well, what about settlements? Well, just one little bit here. In-stream flow cases, we've got, I've got 4 of them up there. 3 federal cases involving fishing tribes where the courts have recognized that tribes that have either a treaty, off-reservation treaty fishing right or a history of fishing have rights to in-stream flows to protect those fisheries with a priority date of time immemorial, which is pretty good. And so, again, 4 cases, state Supreme Courts, 9th Circuit. We know what happens at the 9th Circuit when one of their cases goes to the Supreme Court. So, again, but they can't take every case, right? Or they don't take every case. And so, what happens? Nothing. Water settlements. So we get money. We call it wrapping yourself in the Indian blanket. So the states and the tribes say, well, we'd probably take we'll take a little less water, and let's go to, if we could get some money from Congress and maybe some land back, and we'll get some money from Congress to help the non-Indians become more efficient so that there'll be less consumptive use. And we'd also like to have a tribal development fund that we could utilize to actually provide potable water to the reservation, because remember, in the Wind River case out of Wyoming, the tribe got a big award of water for irrigation, but all they had at the end of the day was a piece of paper, a paper right, with no money to put the water to use. And so we started thinking about, well, how could we make these adjustments? And so we ended up with these series of massive settlements, and 4 of them passed in 2010 in the lame duck session of Congress. They're hard to find because they're usually buried in recent years in a 900-page appropriations bill, and they only take up about 3 or 4 pages and incorporate decrees and other side agreements that are very hard to track down unless you're actually one of the lawyers that was involved in the case. But this is how the deals are being done now in the water rights arena. There's 25 federal negotiation teams right now involved in litigation. And so that's the quantity side of these cases. And what about quality? Well, there's 2 aspects to water quality. One, the Clean Water Act provides tribes with the ability to obtain treatment as a state. So the Clean Water Act sets minimum federal standards, let's say for water quality standards for the waters of the United States. States have the authority to administer the statute if they wish, and tribes can obtain the same authority to do so. It's this familiar cooperative federalism approach. Tribes, under the Clean Water Act, though, have to show that they have inherent authority over water resources within their reservations, including the non-Indian lands, which are present in most reservations. Well, when this rule was adopted, it was prior to a series of adverse decisions in the Supreme Court that have curtailed tribal authority over non-Indian fee lands within Indian country. Nevertheless, the EPA rule, which presumes tribal jurisdiction over non-Indian lands because of the importance of water to life generally that we're all familiar with, has withstood 3 challenges in the 10th Circuit, the 7th Circuit, and the 9th Circuit. So it seems to be fairly stable right now, and maybe the Supreme Court won't take a case that would challenge EPA's presumption of tribal authority in these cases because it's got this bureaucratic check on the tribe, similar to other cases that we've seen. The Hickory oil and gas case comes to mind. But what happens under this scheme is really kind of interesting. The tribe gets certified as a state for purposes of implementing the Clean Water Act. It has to show that it's a tribe. Well, we can look on the Federal Register list and determine that. It has to show that it is capable of administering the program. Well, they send in the organizational chart and show that they've got money to operate their government. And third, they demonstrate this inherent authority over waters within their jurisdiction. And at that point, tribes set water quality standards that can be more stringent than the federal standards. And in Albuquerque versus Browner, instead of Pueblo set standards that would require Albuquerque to spend about an additional $10 million on its water treatment plant. Because when you have these more stringent water quality standards, people upstream who want a permit to discharge, which the city of Albuquerque did here, and so the city goes to EPA and says, we want a permit, and the tribe said, the EPA says, well, giving you this permit under these conditions is going to interfere with the downstream water quality standards set by the tribe, and therefore, we're not going to issue it. At that point, the litigation commences, and the 10th Circuit upholds EPA's authority to reject this permit based on the downstream tribal water quality regime. And so you don't have the tribe enforcing against the off-reservation water user or discharger or polluter, depending on how you want to view it. Instead, the tribe sets standards within its jurisdiction, and EPA enforces off the reservation through this permitting process. And it cuts the other way too. So a tribe discharging on its reservation or issuing a permit to discharge to a non-Indian on its reservation can't interfere with a more stringent permit or water quality standards set downstream if the state has set it in that fashion. And EPA is the one that decides whether these permits will issue. They're the ultimate checkpoint here. So it's a pretty interesting regime, and their regs have a procedure for mediating and discussing how these interests of the parties can be dealt with. Tribes